Yes, Member Curry.
Yes, indeed, out here too.
All right, good afternoon. This is a continuance of our hearing on EIB 2561. I'd like to call the meeting to order at 13:04. Pam, can you take a roll call to make sure we have a quorum?
I will. Good afternoon. Member Bitzer, are you present? Member Bitzer? Member Carrasco?
Present.
Member Curry?
Present.
Chair Ely?
Present.
Vice Chair Sweeney? Member Bitzer, can you hear us and indicate that you're present? Back to you, Vice Chair. Can you weigh in on your presence on the platform? Okay, we got a thumbs up. Member Bitzer.
Yeah, there's still a few remaining. If we can.
And did he say something?
Is that muted?
Member Bitzer, you're unmuted. Can you turn your camera on? Try to turn your camera on so we can see you. Now I don't see him on the platform, actually. Oh, there he is. Member Bitzer, one more time. Can you hear us? Madam Chair, he's
Yes,
on the
yes,
platform.
indeed.
But
yes.
okay,
Yeah,
there you go.
I can hear you.
Madam Chair, you have a quorum.
Thank you, Pam. So this afternoon we'll be deliberating on the PFAS rule, again, EIB 2561. We'll hear closing arguments and then move into some of the motions that were filed and deliberate on the rule itself. Madam Hearing Officer, would you like to take it away on the closing arguments?
Yes, thank you very much, Madam Chair. My name is Felicia Orth. I'm a hearing officer appointed in EIB 25-61. This is the proposed adoption of 20.13.2 and MAC, burn polyfluoroalkyl substances in consumer products. We proceeded through 4 days of hearing, and at the end of that 4 days, had come to the end of the technical evidence. So we adjourned without closing the record. The record was left open for additional written, non-technical public comment, any closing argument, proposed findings, or other post-hearing submittals, non-evidentiary post-hearing submittals that the parties wanted to submit. All of that was to come in by yesterday at close of business. Got a number of documents. And before we close the record, we will have oral closing argument, not to exceed 20 minutes per party. We'll go in reverse order. so that the petitioner gets the last word. Mr. Weatherby, I don't know if you're on the platform or not. Do you have anything by way of a closing statement? I don't hear Mr.
Can you
Weatherby.
hear me?
Oh, yes, now I can.
Okay, I had trouble unmuting. Thank you, Madam Hearing Officer. I simply had a couple of sentences I wanted to offer. I wanted to thank you and particularly the members of the EIB for this hearing, the department for its presentation, and all the other parties. I think this is an important rulemaking. As I read the law, the EIB actually is the body that makes the decision. And given the importance of this issue and the many issues relative to PFAS, I encourage you to exercise your full authority to provide protection to members of the public, including people in the workforce. So I thank you all. This has been a very informative test. I'd like to thank Mr. Ugarte, Mr. Luis and Pam for their assistance through this process as well. It's been a very professional experience and I appreciate it. Thank you.
Thank you very much, Mr. Weatherby. Let's see, I don't see Mr. Harris or Mr. Boutier in the room. Are you on the platform, Mr. Harris or Mr. Boutier? All right, Luis is saying that he does not see them on the platform. So then we'll move to Mr. Mullenberg. Would you like to offer some closing statement?
Let me get this on. We'd like to proceed first with a short statement by CropLife, and then we can go to American Chemistry Council, and Ms. Saluha will present on CropLife.
All right, thank you very much, Ms. Saluha, please.
Good afternoon, Madam Hearing Officer and members of the board. My name is Serafina Saluha, and I am delivering this closing statement on behalf of CropLife America. CropLife appreciates the department's inclusion of language in the final proposed new rule 20.13.2 NMAC that addresses CropLife's primary concerns with the proposed labeling and reporting requirements. CropLife also expresses its appreciation for the board's work in this rulemaking. CropLife supports the department's final proposed new rule, clarifying that pesticides regulated under the Federal Insecticide, Fungicide, and Rodenticide Act, FIFRA, are exempt from the proposed labeling requirements, consistent with the statutory exemptions in the PFAS Protection Act. The rule is now proposed, as well as the Act appropriately recognizes that pesticides are already governed by a comprehensive federal regulatory framework that rigorously evaluates product safety, labeling, and approved uses before any pesticide may be sold or used in the marketplace. As our witness, Dr. Basu, explained, before a pesticide can be distributed or used in the United States, it must undergo extensive technical review by the United States Environmental Protection Agency. EPA must approve the product's label, which provides detailed instructions governing how the pesticide may be used, and those labels are legally enforceable and must be followed at all times. EPA also continues to oversee pesticides after registration through ongoing scientific review and regulatory oversight. Given this existing and comprehensive federal framework, additional or overlapping state requirements would not enhance protection of human health or the environment. Instead, they risk creating inconsistency and regulatory confusion for products that are already heavily regulated at the federal level. For these reasons, CropLife America respectfully urges the board to adopt the department's final proposed new rule, incorporating the statutory exemption for FIFRA regulated products in section 20.13.2.10Q and the exemption from the labeling requirements as provided in section 20.13.2.13b2. Thank you.
Thank you, Ms. Aloha. Mr. Mullenberg.
Thank you, Madam Hearing Officer, Madam Chair, members of the board, and council. The American Chemistry Council appreciates the opportunity to appear here today, as well as the opportunity to participate in the hearing of this matter. Let me begin by saying that when we left the hearing last Thursday, which seems now like about a month ago, we expressed some concerns about the quick nature of deliberations in light of kind of the customary opportunity to do written closing arguments for the board's consideration. At the time we left, we didn't anticipate that we would have a transcript available, which thanks to our court reporter and his fine work, we actually did. So we were able to put together a written closing argument, which we filed yesterday, which actually contains citations to the transcript and other parts of the record. So before I start with oral closing, I would just point out that that is available, and fortunately we were able to do that. We also filed a written statement of reasons and a final red line. So the focus of American Chemistry Council during the hearing was really pretty singular on the issue of labeling and whether the board should exclude those products that are exempt by statute and by rule from all of the other requirements of the Act, particularly the prohibitions, restrictions, and other requirements on products containing intentionally added PFAS and the reporting requirements. Just by way of preface, I'm going to cover a couple of other issues that we've raised during the hearing. There's one other minor change to the proposed rule that you can find in our Exhibit 7, the red line, and that is something we believe is necessary to conform to the statutory structure. And it's simply to add a reference to, I believe it's 20.13.2.9 in the list of things covered by the exclusions. That's explained in our written submittal. We also, as have some other parties, recommend that the date of compliance for the labeling requirements be extended by a year to January 1 of 2028. Several parties submitted written comments on that point, and CPMC presented what we think is some pretty compelling testimony regarding some of the challenges and difficulties complying with the labeling requirement, as did again a number of other parties, and we've outlined that in our written submittal, the comments by the other parties. The last change, and I'll talk about this in a little more detail, is the issue of fees, and we've addressed that in our written closing argument as well as a motion. Madam Hearing Officer, I don't know if you intend to take argument or do anything further on the motion, but I'll address that issue as part of the closing argument as well. So As I began saying, American Chemistry Council's primary focus and the primary focus of the hearing is the objection to the department's proposal to apply the labeling requirements to products that are exempt by both statute and rule from the other requirements of the Act and the rules. And I've mentioned those requirements earlier. ACC introduced 2 witnesses who contested the department's view that the board should adopt regulations covering PFAS products uniformly as a class, treating all the same for labeling purposes, when the technical testimony shows that PFAS compounds have very different characteristics that warrant different regulatory approaches. Those characteristics include molecular size, mobility, solubility, bioavailability, bioaccumulation potential, and toxicological effects. The legislature specifically provided that many types of products containing PFAS should be treated differently by exempting a number of products from the other requirements of the Act. Regarding the technical testimony, ACC's witnesses have the academic credentials, decades of experience in the field, and have authored important peer-reviewed literature on the topics of their testimony. Their testimony was compelling on these points. Those points really being the differences in the characteristics of different PFAS compounds. The department's witnesses generally agreed with many, in fact, just about all of the differences in characteristics among the different types of PFAS, including polymeric versus non-polymeric PFAS and fluoropolymers specifically. At the very least, the department's witnesses did not refute the important physical and toxicological differences in the different types of PFAS. Regarding fluoropolymers specifically, no witness disagreed that they are insoluble. One of the important points of emphasis by the department is the concerns with PFAS in groundwater. No one disputes that PFAS compounds in groundwater, particularly groundwater serving as a water supply, is an important and worthy issue for the board to address. And no one disputes that the department's view that stopping the spigot of PFAS by regulating and even prohibiting products containing PFAS that pose a threat to groundwater when released is a sound approach. Because fluoropolymers are not soluble, however, they are not found in dissolved form in groundwater. This is a critical difference. I will add too that no party is disputing that PFAS compounds provide valuable and important qualities to many materials that are used in everyday life, and that EPA and other agencies have deemed the use of many products as safe. That includes things like medical devices implanted into human bodies and elements of electronic devices that cannot be produced in their current form without the use of PFAS compounds. These factors were considered by the legislature when it adopted the exemptions. Both the scientific testimony in this case and principles of statutory construction support ACC's proposed language changes to the proposed rule that are intended to exclude from the labeling requirements all of the products that were exempted from the other requirements by the legislature, as well as the restatement of those exemptions in the proposed rule as offered by the department. Moving on to other issues, and again, these the details of these arguments are stated more fully in the written closing argument. ACC and other parties, as I've mentioned, offer another change to postpone the effective date of the labeling requirements for a year to January 1 of 2028. Our written closing argument identifies many of the written comments and comments made orally to you at the hearing that stated simply that there really isn't sufficient time for compliance with the labeling requirements by the beginning of next year. That has important implications, we believe, for the delivery and availability of products in New Mexico and perhaps elsewhere as other parties raised interstate commerce concerns with the labeling requirements and the deadline. There are a number of other issues that have been raised by ACC during the hearing. First is ACC's motion in limine that objected to the hide the ball approach taken by the department, contrary to the express requirements of both the State Rules Act and the board's rules governing rulemakings. The hearing officer denied the motion, but allowed ACC to cross-examine the department's witnesses to confirm the facts stated in the motion. Cross-examination indeed confirmed those allegations. ACC also preserved its objections to the introduction of technical information offered in support of the rule that was not cited or made available when the public notice of the hearing was published. ACC renews its motion and urges the board not to consider technical information offered by the department during the hearing that was not identified with a public notice and not offered in rebuttal testimony. ACC, along with other parties, have objected to the department's proposed definition of consumer, because that definition, in combination with the word product, creates confusion among the regulatory community. And that's because the statute specifically defines consumer products in terms of things like products used by a household. Those concepts are not included in the definition of consumer as adopted or as proposed by the department. And it really is raising some serious confusion and questions on the applicability of the rules or parts of the rules. American Chemistry Council's proposal in that regard is simply to omit the definition of consumer from the rules. We think that's the simplest approach, and we're not really sure why that definition is critical to the rules. Alternatively, we would note that CPMC has proposed alternative language for the definition. Finally, we come to the issue of fees. In all frankness, fees was not a focal point of the American Chemistry Council, but once we got into the hearing and took a look at the issue, and particularly the magnitude of the fees to be collected as proposed by the department, which is estimated at over $20 million in the first year and $15 million of that coming from applications for waivers from the labeling requirements. It caused some concern. Whether you look at it in the context of the motion to dismiss, the written closing arguments that we've submitted, or the authorities cited by the department, in the department statement of rules, the Act provides no express authority for the board to adopt any rules regarding fees. The department in its statement of reasons has offered some general authority, but we don't even see that that specifically authorizes the board to adopt any rules relating to fees. This is a really critical issue. It's the legislature that has the plenary power to constitutionally to impose taxes, and to impose or authorize the imposition of fees. There's a related, very important document or concept that's stated in our papers, and that's the non-delegation doctrine. And it's a body of law that says if the legislature delegates its authority over things like imposition of fees, the legislature has to provide reasonable guidance and direction on those fees, what they're to be used for, limitations on the amounts, and those kinds of things. That guidance is entirely lacking in the provisions cited by the department. I want to mention there's actually an important and very telling Attorney General opinion on this point. It's opinion number 88-78. There's not a lot of case law and such in New Mexico dealing with this topic specific to fees. But in that Attorney General opinion, they took a close look at the ability to delegate authority to impose fees and the limitations on that, the need for guidance. And that Attorney General opinion concluded that the fees that were sought to be assessed in that case could not be lawfully assessed. So as I say, one way or the other, I think the board's going to have to grapple with this legal issue on fees. I should also say that the Chemistry Council is sympathetic to the need for the department to have funds to administer the law. And the Chemistry Council, as most other parties, don't object to those provisions of the proposed rules governing and matching the statutory requirements as it relates to product prohibitions, restrictions, applications for exceptions, and reporting. Those are all important things, and the Chemistry Council and I believe most other parties actually support those things. So we see the conundrum, but we don't see a way around the issues of legal authority and, in fact, constitutional issues that come up in this regard regarding separation of powers and those types of things. Again, the details are addressed in our written submittals. I know that the board has not had a great deal of time to review or consider those documents, but we think all of these issues are worthy of consideration. And we would hope that if the board, as we believe its intent, proceeds to the adoption of the rules, the board will carefully consider the changes that have been offered by the American Chemistry Council and the reasons for those, including the legal arguments in the papers we filed. Thank you very much again for your time and attention. It's a very important issue, and we know that the board has some weighty matters to consider.
Thank you, Mr. Mullenberg. Let's see, Ms. Feebig, are you online?
Yes, hi. I'm here.
Yes, hello.
How are
Would you
you?
like to offer some closing argument?
Yes, thank you. Afternoon, Madam Hearing Officer, Madam Chair, Madam Vice Chair, and members of the board. This is Rebecca Feebig from Wiley Rhine. I'm appearing on behalf of the Complex Products Manufacturers Coalition and the Alliance for Automotive Innovation. Lovely to see you all again, and I thank you for the opportunity to provide some closing thoughts before you move into your deliberations this afternoon. CPMC and auto innovators support significant aspects of the proposed rule. However, other aspects of the rule would be unlawful, unsupported by the evidence, or unworkable if adopted as proposed. CPMC and Auto Innovators thus respectfully ask that the board adopt the rebuttal rule as modified in the proposed order and attachment A that we submitted with our statement of reasons yesterday afternoon. The specifics of our proposed modifications are reflected in the written materials, and I cannot cover every detail in our time together today, so I thank you in advance for giving them a close review together with the statement of reasons and our written comments. Today, I will focus primarily on our concerns regarding product labeling, timing, and the need for revisions to avoid preemption problems. As to labeling, it's important to consider the scope of the board's discretion. For that, it's helpful to identify what is required and what is prohibited. Once we've identified those parameters, we can consider the evidence presented and determine what is reasonable and justified. So what is required under the statute with respect to labeling? The answer is nothing. The board is not required to impose a labeling requirement on products. That's clear from Section 4B in the PFAS Protection Act. It's completely within your discretion to decline NMED's request to require labels altogether, and it may be prudent to do so, at least temporarily. What is prohibited? A few things. First, compelled statements that are misleading or controversial. The First Amendment to the U.S. Constitution and Article 2, Section 17 of the New Mexico Constitution, which are generally interpreted consistently, only allow compelled commercial speech that is purely factual, not misleading, and not controversial. The department proposes including a label on all products that contain PFAS, regardless of the risk that they pose. In earlier iterations of the rule, it was very clear that the purpose of the label was to tell consumers that PFAS is dangerous. The department has pulled back on express hazard language on the label, which is certainly appreciated and certainly a move that we support. But even the current iteration being proposed, which must be considered in the context of the department's stated goal to dissuade PFAS use and alongside its public efforts to tell consumers that PFAS are dangerous, remains misleading and controversial. The reason for that is that PFAS includes 14,000 chemicals, as we heard many times last week. The definition in the law is structure-based, not risk-based. The risk-based element of the Act is in the exemptions. At the hearing, we heard testimony from multiple witnesses, including Dr. Olson, Dr. Stanton, Dr. Chapman, Dr. Henry, Dr. Korzanowski, and Dr. DeWitt, regarding the differences between these chemicals. We heard that some of them are known to be harmful and significant efforts have already been undertaken to decrease their use. We heard that some of them are considered to be safe, even after decades of use. And we heard that a lot of them need further study. The question of PFAS risk is neither settled nor non-controversial. Putting a label that implies a hazard on some of these products is going to be misleading. The legislature has already done the work of determining which categories of products present a low risk and exempted them from product bans. The board should follow its lead and extend the Act's exemptions to its labeling provisions. What else is prohibited? Regulations that impose reporting requirements on products that are exempted by statute. We, and any other commenters, have spent a lot of time on Section 4B of the Act, which gives the board discretionary authority over labeling. But we can't lose sight of Section 4A, which is mandatory. Section 4A says the board shall adopt rules to exempt from the reporting requirements of the Act any product that is exempted from the ban or found to be a currently unavoidable use. And what does that have to do with labeling? To determine whether to label, companies have to gather the information that would be needed to report. So in imposing a labeling requirement, you would be imposing a reporting requirement, at least in part. As we learned at the hearing, the information gathering is the most difficult component of the reporting process. Under the complex durable goods provisions in the rebuttal rule, which the department has thankfully withdrawn, companies also had to report that information to the public. CPMC and Auto Innovators certainly support withdrawal of that aspect of the rule and thank the department for their efforts in that respect. Still, to obtain an exemption from labeling under the current proposal, a party has to provide the information required by the reporting requirement and more, and specifically the chemical information regarding the PFAS that is contained in the product. Adopting a rule that exempts exempted products from the labeling requirement would fix this. Another thing that is not allowed, regulations that do not carry out the provisions of the statute. The board's discretion to impose labels is limited by the preceding language, which states the board may implement rules to carry out the provisions of the statute. As I noted before, the legislature made the risk-based determination to exclude several categories of products from the ban and reporting requirements. Extending those exemptions to any labeling program is a clear example of carrying out the provisions of the statute. Finally, the last thing that is not allowed is regulations whose burdens far outstrip their benefits. Regulations that are extremely burdensome with little or no corresponding benefit are generally found to be arbitrary and capricious. So how can we avoid overstepping the board's discretion? Option 1 would be to decline to impose a labeling requirement on products at this time. Option 2, and this is the option that CPMC, Auto Innovators, and ACC as well are suggesting to the board, is to extend the exemptions in Section 3A of the Act to the labeling provisions. Taking this action would limit the likelihood that a misleading label will be affixed to a product that presents little, which alleviates First Amendment concerns. This avoids imposing reporting requirements on exempt products in violation of the statute. It's clearly consistent with the provisions of the statute, as it mirrors the terms of the statute and the risk determinations that were already made. It's also consistent with the broader goal of providing choice for consumers specifically, as many complex durable goods are sold business to business. Finally, it's supported by the evidence. As the evidence at the hearing showed, labeling these products provides little benefit to consumers. Most of the PFAS in New Mexico does not come from consumer products, and there is no evidence to show that complex consumer products are a contributor, never mind a consequential contributor, to PFAS contamination in the New Mexican environment. The products either present minimal risk, as explained by Ms. Maripes, Dr. Stanton, Dr. Henry, and Dr. Korzanowski, and thus consumers paying a premium to avoid them are potentially losing money. Or the products are required to contain PFAS by federal law or represent unavoidable uses, meaning that a label will not bring any corresponding ability to make a meaningful choice. Conversely, the burdens to companies associated with compliance are likely to be very significant. As an alternative proposal to extending all 16 exemptions that are set forth in Section 3A of the statute, CPMC and Auto Innovators would encourage the board to consider extending some additional exemptions, such as those for motor and other vehicles, watercraft, SNAP refrigerants, and for fluoropolymers. There is specific evidence throughout the record demonstrating that these items are necessary, unavoidable uses. Specifically, in the case of SNAP refrigerants, they are required to be used by federal law, so adding a label to those products is not going to provide consumers with a choice. And the same can be said for vehicles and watercraft, many of whose PFAS-containing components are required by federal safety standards. Or in the case of fluoropolymers, there is substantial evidence to suggest that they really do not provide a substantial risk of harm to human health or to the environment, as discussed extensively by multiple witnesses during the hearing. If the board elects to impose a labeling requirement, CPMC and Auto Innovators wish to emphasize that it is imperative that complex durable goods be granted more time to comply. The record is replete with comments from industry on this, as Mr. Mullenberg just highlighted for the board. And Ms. Solomon testified on this issue at the hearing to give you a specific perspective on the issues facing industry. We therefore ask that the labeling date, if labels are imposed, be at least 1 year from enactment and ideally January 1, 2028 to align with product design cycles. And that brings me to my final point, which is the need to revise the rebuttal rule to provide clarity to companies whose components are required to comply with federal safety standards. The rebuttal rule exempts motor vehicles and watercraft from its bans, but fails to provide needed clarity on how certain components should be treated. For motor vehicles, there is an exemption from the exemption for textiles and refrigerants. The reality is, both the textiles and the refrigerants are generally required by federal law, meaning they cannot be banned. We raised this point and were told that other provisions of the proposed rule address the issue. We asked the board to incorporate language in the final rule that explains how the different provisions interact. This is necessary to avoid any regulatory construction questions, such as the suggestion that the specific trumps the general in the future, and provide certainty for industry attempting to comply with the rules. For watercraft, the exemption does not specify whether it applies to associated equipment that is required to be included in a vessel, such as a life jacket. We ask that the board provide clarity on this issue via the final rule. Finally, we ask that the board recognize that preemption results in unavoidable uses and allow companies the flexibility to show that components may be necessary to meet safety standards, even if not called out by name in a federal regulation. I want to thank the board for its careful attention at the hearing and to the materials in the record. As I said when we first met, these are difficult but important issues. New Mexico is in a position to lead the nation here with science and risk-based regulatory action that is thoughtful and impactful. Thank you.
Thank you, Ms. Feebeck. Mr. Boutier, do you have any thing to offer?
Officer, the PFAS pharmaceutical working group waives closing argument, and as stated.
Thank you very much. Mr. Boutier just stated that pharmaceutical working group waives closing argument and takes no position on Mr. Muhlenberg's motion. Mr. Smith here.
Thank you, Madam Hearing Officer, Chair Ely, and members of the board. I had a couple of preliminary matters based on Mr. Muhlenberg's presentation, and you may direct me that this is appropriate to address after our closing. But first, he raised arguments from their motion to dismiss, and I would like to ask that my colleague, Mr. Rosebrough, be able to respond to those.
I believe that to the extent there'll be any argument on any of the motions that the chair and Mr. Ugarte are going to handle them.
Okay. The second point I'd like to make is that I learned for the first time during Mr. Muhlenberg's closing arguments that ACC filed written closing arguments. It was the department's understanding that we were only to do oral closing arguments. We certainly would have filed written closing arguments if we'd known that was permitted. And so we would make a motion to strike that from the record. That may be more appropriate after closing arguments.
Okay, so that might be on me then for not being clear. That it all of it was discretionary. That documents that didn't represent evidence but represented argument or proposed statement of reasons, what have you, and non-technical public comment could come in until close of business yesterday. So if I was unclear about that, I'm sorry.
Okay. Thank you, Madam Hearing Officer. My name is Greg Smith here. I'm here on behalf of the Office of Strategic Initiatives in the New Mexico Environment Department. On April 8th, 2025, New Mexico Governor Michelle Lujan Grisham signed the PFAS Protection Act into law. The PFAS Protection Act requires that the Environmental Improvement Board adopt regulations related to reporting and currently unavoidable use determinations. In addition, the PFAS Protection Act authorizes the board to adopt regulations to require labeling of products in English and in Spanish. While the act is permissive with respect to labeling, the New Mexico legislature passed House Joint Memorial 3 on February 18th, 2026. Among other things, House Joint Memorial 3 clarified the legislature's intent that all products containing intentionally added PFAS, including those categories of products that are exempt from general prohibition, are required to have a label. The PFAS Protection Act provides the board with the authority to provide New Mexicans with the transparency that they deserve by requiring manufacturers to label consumer products containing intentionally added PFAS. A transparent labeling requirement will empower consumers to make informed decisions with respect to the everyday products that they bring into their homes and expose their families to. The proposed label is comprised of a simple and true statement, which is based on a consensus definition of PFAS that is contained in the PFAS Protection Act. The label will inform New Mexicans of the presence of PFAS in a product so that they can utilize that information as they deem appropriate. Last week, you heard from 10 technical witnesses who testified on behalf of the Environment Department. Their written and oral testimony provided the board with all the evidence that it needs to adopt the proposed final rule as written. The department's witnesses provided testimony demonstrating the significant harm of PFAS contamination with respect to human health, the environment, animal and plant life, water resources, and property values. They also testified with respect to the economic reasonableness of the proposed rule, including labeling. With respect to the impact of PFAS on the environment, Dr. Eric Chapman provided extensive written and oral testimony. Importantly, Dr. Chapman testified regarding the full life cycle analysis with respect to PFAS, focusing on sources, transformation, transport, and fate of PFAS in the environment. As you heard from Dr. Chapman, primary sources of PFAS in the environment include, among others, commercial production and consumer products. Once PFAS enter the environment, they contribute to secondary sources that receive PFAS contamination, including wastewater, treatment plants, landfills, and the land application of biosolids. PFAS can also undergo both biogeochemical and abiotic transformations within various environmental media, such as water, soil, and air. This often leads to degradation into smaller and more persistent PFAS. Dr. Chapman testified with respect to the importance of considering the full life cycle of PFAS in the context of fluoropolymers. You have heard testimony with respect to the stability of fluoropolymers and their tendency not to degrade in the same way that non-polymeric PFAS do. However, when one considers the entire cradle-to-grave life cycle, it reveals that non-polymeric PFAS are utilized during the production of fluoropolymers, which leads to the potential for environmental contamination of non-polymeric PFAS in the areas that fluoropolymers are produced. In addition, at the end of the life of a product that contains fluoropolymers, there are additional opportunities for non-polymeric emissions into the environment during a product's disposal, whether that be through landfilling or incineration. CPMC's own expert, Dr. Alex Stanton, testified that all PFAS that meet the statutory definition of PFAS in the Act share the trait of being persistent in the environment. She also testified that there are thousands of PFAS that have not been well studied, and therefore we don't know if they're toxic. You heard testimony from Dr. Jamie DeWitt, who spoke about the dangers of PFAS exposure due to the strong evidence linking PFAS to numerous adverse health outcomes. She discussed some of the well-studied PFAS, such as PFOS and PFOA, and their links to the increased risk of kidney and testicular cancer, effects on child development, such as low birth weight, and damage to the immune system, liver, and endocrine systems. Dr. DeWitt also testified that emerging research on lesser studied PFAS is troubling because these chemicals appear to share similar health risks with the more studied PFAS like PFOS and PFOA. In addition, she testified with respect to precursor degradation, and that some lesser studied precursor compounds degrade into PFOA and PFOS and other persistent PFAS within the environment and even inside of the human body. Dr. Allison Ling testified during the hearing that cleaning up PFAS after environmental release is economically and technically infeasible. Dr. Ling estimated that removing just PFAS at their current emission rates would cost between $1 and $65 trillion a year, which is comparable to the global annual GDP. Because of that, the most effective way to protect public health is to turn down the tap by reducing the use of non-essential PFAS in products and limiting industrial emissions at the source. Last week, you also heard from Andy Yocums, NMED's Source Water Protection Lead, regarding the unique challenges that New Mexico faces with respect to PFAS in our drinking water and the paramount importance of source water protection. New Mexico is a rural state, and about 80% of the population relies on groundwater for drinking. There are over 1,000 regulated public water utilities in New Mexico, many of which are small, and approximately 105,000 New Mexicans rely on private drinking water sources, such as private wells, which have no regulations to protect their quality. The cost of remediation disproportionately impacts these small water systems, as they often lack the resources to install and maintain the expensive technologies required to treat PFAS. Because of that, applying proactive measures are necessary, as they are less expensive and more reliable than remediation. Last week, you also heard testimony from Cabinet Secretary James Kenney, and he provided some startling examples of the real-life impact PFAS is having on New Mexicans. He testified with respect to the agricultural devastation that PFAS has caused, including one Curry County dairy farmer who was forced to euthanize over 3,660 cows and dispose of millions of gallons of milk because of PFAS contamination. Secretary Kenney provided testimony with respect to New Mexicans who have experienced devastating impacts on their real property values due to PFAS contamination. And he also described the threat of PFAS contamination to New Mexico's tourism sector, including the unprecedented levels of contamination and wildlife around Lake Holloman, impacting areas adjacent to White Sands National Park. Secretary Kenney testified that as PFAS continues to show up in New Mexico's drinking water sources, including the Children's Garden Montessori School in Santa Fe County, Placitas Elementary School in Sandoval County, and Leisure Mountain RV Park in Bernalillo County, the department has expanded its duties to provide private well water testing and home filtration systems related to PFAS contamination. In addition, the department is administering infrastructure funding to connect homes with private well water to public systems as residential property values drop because of contaminated drinking water. As Secretary Kenney testified during the hearing, the proposed fee structure is essential to cover the department's recurring costs. These fees will directly fund the technical, legal, and IT experts needed to manage reporting, handle label waiver requests, and review the program's currently unavoidable use applications. By adopting this model, the board ensures the cost of administration is borne by the regulated community and not the general public. This fee-for-service approach isn't new, and this model is consistent with how NMED successfully manages other programs. As you heard last week, Dr. Richard Melstrom testified about the benefits that New Mexicans would receive from the proposed labeling requirements. Dr. Melstrom is an expert in environmental economics, and he has shown that consumers value information related to PFAS in consumer products. He testified that a conservative estimate of the annual benefit to New Mexican households exceeds $121 million a year. As Dr. Melstrom testified, the labeling requirement in the proposed rule is economically reasonable. Based on this testimony, the proposed labeling requirement is not an undue burden, but rather a high-value investment in providing transparency to the New Mexico consumer. Dr. Deborah Dickerson testified regarding labeling consumer products during the hearing. She explained the purposes of labels, the need for labels to raise public awareness of PFAS in consumer products, and the effectiveness of labels. As Dr. Dickerson testified, product labels, like the department's proposed label, can be used to raise consumer awareness of product content so that consumers can make informed decisions regarding product use. With respect to label design, Dr. Dickerson explained that effective labels are conspicuous and contain graphical content, such as a graphic symbol, which conveys meaning through resemblance to a physical object. According to Dr. Dickerson, the department's proposed Erlenmeyer flask label is an effective label as designed. She also testified that the proposed label would be a solution to close the knowledge gap that consumers have with respect to the presence of PFAS in consumer products and raise awareness of this issue. With respect to the costs associated with the proposed labeling requirement, Dr. Dickerson concluded that the one-time label-related costs to manufacturers would not have a prohibitive impact on consumers or companies. To summarize, You have heard from human health experts about the toxicity of some PFAS and the serious health conditions that are linked to their exposure, and about bioaccumulation of PFAS in plants, animals, and humans. You have also heard from environmental science experts about PFAS's environmental impact, including their incredible persistence in the environment and the necessity of analyzing the impact of PFAS from a full life cycle perspective. You have heard about the economic impacts of PFAS on New Mexico, including the staggering costs of remediation once PFAS have been released into the environment. You have also heard about New Mexico's drinking water systems, many of which are small and private, which highlights the importance of source water protection in our state. All the testimony presented by the department leads to one conclusion: that the only feasible way to address the PFAS problem in New Mexico is to stop it at the source and turn off the spigot of PFAS in our state. The prohibitions that have already been put into place by the legislature are one tool in achieving that goal. Labeling of consumer products containing PFAS is another powerful tool that will place agency in the hands of New Mexicans to make informed decisions with respect to the everyday products they bring into their homes. New Mexicans deserve transparency with respect to the chemicals contained in consumer products, and the board has the authority to require manufacturers to provide that transparency. The department has clearly demonstrated that this proposed final rule is lawful, backed by substantial evidence, and fully consistent with the legislature's directive in the PFAS Protection Act and House Joint Memorial 3. This is not just a regulatory formality. It's a measured, science-based response to a clear mandate from the people of New Mexico as expressed through their elected representatives. Time is of the essence with respect to adopting this rule. The first product prohibitions go into effect on January 1st, 2027. Manufacturers will need a way to fulfill their reporting requirements under the PFAS Protection Act, and the department needs a finalized rule so that it can complete its work on the IT system that manufacturers can utilize for reporting, currently unavoidable use requests, and label waiver requests. By creating this aggressive timeline, the legislature made the urgency of this issue clear. For all of these reasons, the department is respectfully requesting that the board adopt the final proposed rule as written. Thank you.
Thank you, Mr. Smith-Care. As I said, I don't know whether they will be inviting additional argument on the motion, but you do still have 6 minutes if your colleague would like to offer a few more words on the motion to dismiss.
Madam Hearing Officer, members of the board, Mark Roseborough on behalf of the department. And thank you for the opportunity to present a response on the ACC's motion to dismiss for lack of subject matter jurisdiction. I'd like to start with the extremely late filing of this motion. It was filed 37 days after the deadline to file dispositive motions and 44 hours before we showed up here today. The EIB's rulemaking procedures are clear and they control here. First of all, and the ends of hearings are chaotic, and I understand that you believe it may have been unclear, but I would respectfully point out to the board that when we reviewed the record, counsel for NMED, Andrew Knight, asked, is the record closed? The hearing officer gave ACC the opportunity to submit its motions, and then the record was closed. There was nothing on the record that said post-hearing submissions are allowed. So let's turn to the rulemaking procedures so we can understand the rules governing post-hearing submissions. 20.1.1.404 says that the hearing officer may allow the record to remain open, but that such a decision shall be announced at the conclusion of the hearing. In NMED's review of the record, nothing was said either way allowing post-hearing submissions, and therefore we would contend they're untimely. And then just as a matter of law, under the rulemaking procedures, the ACC's motion to dismiss is untimely, should be denied, and should be stricken from the record. But I'd like to elaborate on that a little further. So ACC styled its motion as a motion to dismiss, which means it's a motion of pure legal issues. There's no reason that they can claim they had to wait until the testimony of anyone at the rulemaking hearing. There's no reason why they can say that they were unable to identify the purely legal issue and file it by January 26, 2026, the dispositive motion deadline. They simply did not do so. They did not request to leave it open after the hearing. And there's absolutely no reason why they should be able to file this 11th hour motion. With that in mind, that procedural argument in mind, I'd like to turn to their arguments about subject matter jurisdiction. And I just note that their motion doesn't define subject matter jurisdiction, because if it had, they would have had to acknowledge it didn't mean what they argued it means. Specifically, or simply put, subject matter jurisdiction is the power of a court, or in this case, an administrative body, to oversee the type of proceeding that it's overseeing. And so ACC contends that subject matter jurisdiction is derived from the PFAS Protection Act. That's not so. Subject matter jurisdiction is derived from the Environmental Improvement Act, which states that the EIB shall promulgate regulations applying to all outside people or entities, to all people or entities outside the department. So that's the subject matter that you have. You have rulemaking authority to applying to entities or people outside the department. So just simply put, everything that flows from that, all these legal arguments, questions of statutory interpretation, reasonableness, all the things we presented evidence on and that you should have a very keen interest in, are not subject matter jurisdiction. Subject matter jurisdiction is, what types of cases are you allowed to oversee? The Environmental Improvement Act says you're allowed to oversee rulemakings. That's subject matter jurisdiction. It derives from the Environmental Improvement Act, not the PFAS Protection Act, and you have subject matter jurisdiction in this matter, irrespective of what the PFAS Protection Act says or does not say about fees. Just to touch on the merits, although I would respectfully say we shouldn't reach the merits of their arguments, the fee authority and the PFAS Protection Act, because they challenge it on subject matter jurisdiction grounds, arguing that the EIB doesn't have it, and it does. But I just want to touch on the fee arguments as well, in case the board is inclined to entertain those arguments. I'd like to start that counsel for ACC cited an attorney general's opinion that he thought was persuasive. He didn't cite it in his opinion, so I'd respectfully take that with a grain of salt. Had it been persuasive, I think it might have been included in his opinion or his motion. The New Mexico Environment Department has broad authority that it derives from the Department of Environment Act, the Environmental Improvement Act, and the PFAS Protection Act as it relates to rules. Rules and including rules which require the payment of fees by regulated parties. So under the Department of Environment Act, quote, the secretary may apply for and receive any public or private funds available to the department to carry out its programs, duties, or services. This is a program that the legislature mandated the department to carry out. Again, under the Department of Environment Act, quote, the secretary may make and adopt such reasonable and procedural rules and regulations as may be necessary to carry out the duties of the department and its divisions. Again, the legislature gave the department duties under the PFAS Protection Act. It has to see over, am I out of time?
Please wrap up.
Okay. I'll say, in addition to those, the Environmental Improvement Act gives similar authorities. The Environmental Improvement Act has similar authority language. The PFAS Protection Act allows this board to adopt rules to implement the program Failure to allow the board or the Environment Department to charge fees would frustrate the intent of the PFAS Protection Act, which requires the department to implement programs under the act. Thank you, Madam Hearing Officer.
Thank you, Mr. Rosebrough. With that, I believe the record, including all closing argument, is in fact closed. So I would turn the proceedings over to Madam Chair. I'm wondering, though, this would be a good time for a short break. All right.
Certainly.
All right. Thank you. Let's come back at 2:25.
25. And I propose at this time that we hear the motion or have a discussion around the motion filed by ACC on Wednesday, March 4th. I'm going to ask Council Ugarte to please summarize what maybe in that motion. I also know that Council made sure that the motion was received by the board members. I mean, there's a flurry of documents coming in. He made sure that the board members had that in front of them, as well as the department's response to that motion.
Thank you, Madam Chair. Actually, I think that the parties here did a really good job. ACC presented the motion during their closing, and then we heard from the petitioner in response. In short, the ACC is challenging the EIB's authority to adopt a fee schedule as proposed in the rule, saying that EIB lacks the subject matter jurisdiction to do that. And then we heard from the department that a different perspective on subject matter jurisdiction and whether the EIB has that. So I'm open to questions if you or the members have any questions on that. I do think that the summary that both parties gave now is helpful. And again, stand for questions.
Well, I'm going to interrupt this for just 1 second. There are two things I think we want to address. And one is Ms. O'Grady didn't have an opportunity to mention the interpretation. So I'm going to allow her to do that at this moment.
And I would just note, Madam Chair, that this is the hearing officer taking my time.
Good afternoon. We are offering interpretation services, and we actually started at the beginning of this hearing. They've been available since 1 o'clock. If there's anybody present here in the hearing room that would like to listen to the Spanish interpretation, please come forward and I'll give you the headsets. Likewise, if you're on the platform and are listening or would like to listen to the Spanish interpretation, just go to the lower left-hand corner of the screen, click on the globe, and then you'll have the option to choose Spanish. Slide the bar all the way over to the right to the interpreter, and that way you will hear only the interpreter. Para alguien que esté en la plataforma que quisiera escuchar la interpretación al español, por favor, vayan al globo que se encuentra en la esquina inferior a la izquierda, pique el globo y allí puede escoger el español. Luego deslice la barrita hasta la derecha para escuchar solamente al español. También para alguien aquí presente en la sala de audiencia, si quiere escuchar la interpretación, pase adelante y con mucho gusto les entrego el equipo.
Thank you, Ms. O'Grady. And I'd also like to ask the board members on the platform, if you can, to please turn your cameras on during this discussion. I think it would be helpful to me to be able to call on you if I can see your faces on the screen. I know Mr. Bitzer may not be able to turn his camera on. He was expressing some issues with that. Thank you. So we left it where Councilor Ugarte was asking if the board had any questions about the motion filed by ACC or the department's response.
Madam Chair.
Member Curry.
I just had a short question for Councilor Mollenberg. I was a little bit curious about when he was talking about the solubility of PFAS and water, and if he would kind of go into that a little bit.
Member Curry, I'm going to ask the board members to stick to the motion at this point.
Okay. All right.
Rather than go into some of the chemistry on PFAS.
Okay. Thank you.
I'd looked at both the motion and the response by the department, and I too had some concerns regarding the timing of the motion. It was filed well past the deadline set in the pre-hearing order. And I also want to note that the labeling and fee language in the rule, in every version of the rule, was there. I mean, this motion could have been brought up at any time beginning last October when the petition was initially filed. So I'm not sure why the motion came at the last minute past the deadline, but I do believe there was plenty of opportunity for ACC to have filed this motion previously. I do want to make one reference or talk a little bit about the merits, and on the labeling piece, you know, the board does have guidance in the Environmental Improvement Act as we move forward with any rule. You know, we must consider the character and degree of injury to the health and welfare of the public, property, and the environment. We must consider the public interest, social, economic, cultural values of the regulated activity, and the social and economic and cultural effects of environmental degradation. Additional guidance is to evaluate technical practicability, necessity for and economic reasonableness of reducing, eliminating, and otherwise taking action with respect to environmental degradation. So I think I understand what they're saying, but I disagree, because I do believe, in addition to the enabling statute, there is guidance. And I also just want to note that the department provided, I thought, an adequate response regarding the fee matter. Is there any, that's what I took away from reading both of those motions. I'm wondering if any other board member would like to comment.
And Madam Chair, if there are no other comments, I think the board you can ask for a motion and then proceed that way.
I think I will. Is there a motion regarding this motion is filed by ACC on Wednesday? Member Carrasco, would you like to make a motion?
Chair, are we making a motion to accept or deny the? I'd move that we deny it due to timeliness.
I'll second that.
So there is a motion to deny by Member Carrasco. There's a second by Member Bitzer. Pam, could you do a roll call vote on that motion?
Yes, Member Bitzer, your vote.
I vote yes.
Member Carrasco.
Yes.
Member Curry.
Yes.
Chair Ely.
Yes.
Vice Chair Sweeney.
Yes, sorry.
Thank you. The motion passes.
Thank you. So for the next bit of time, I'd like to discuss, I'm proposing, I have a suggestion, that we discuss some of the items in the CPMC motion that they filed on January 26th. There were some items in there that the hearing officer suggested that the board take up during deliberations. I think if we have a discussion around some of those items, we could, it will help us as we go through the rule. After that, I then propose that we talk about some of the other high-level matters that came up during technical testimony, and then follow that with a dive into the markups that we've received from the department, ACC, and complex products. I turn to the board members to see if they are agreeable to that. Does that sound like a good approach for the next couple hours?
Yes.
Sure.
So I'm seeing thumbs up and sure. So I think that that's a good way then to proceed. So we've received a lot of technical testimony. We received a petition in October. We got direct testimony submitted January 16th, rebuttal testimony February 16th. Just last week, we had 4 days of testimony that was recorded for all of us to review at our pleasure at home on YouTube. We have received a lot of oral and written comments from both the public and industry. Just yesterday, we got statements of reasons and closing arguments from parties, and just now we heard closing arguments. So we've got a lot of information to digest as we move forward, but it's all very helpful in, I think, sorting through some of these matters that we need to consider right now. So right now, I'd like to turn to our council to perhaps give us a kind of a overview of some of the matters that were in Complex Products Manufacturing Coalition's motion that was filed on the 16th.
Thank you, Madam Chair. Okay, so the motion was broken out into 4 sections, but there really were 3 subjects. They touched on those in their closing arguments here today. The first was this challenge that the labeling requirement violates the constitutional free speech rights. The second was, the second and third were both challenging EIB's authority to do certain things in the rule. And then the final challenge was on the matter of preemption. So just taking those in order, my reading of their motion was focused on compelled speech. Not to bore everybody here, there's a distinction between commercial speech and non-commercial speech. I don't think there's any reason to think this is anything other than commercial speech, and which has a lower standard, and anybody's proposal has changed even with the final draft we got yesterday with what's required in the label. Excuse me, where my understanding is that essentially now it's the symbol. So my sense is that the NMED has responded to the extent they've felt they had to this challenge, and if there are any questions, I'm happy to answer those. And I guess just to check, I don't know if you want me to go through all of them or just one by one.
No, that sounds a good approach. I too believe that the way the department has amended the rule, it deals with a lot of the issues that were raised in the motion. And I just need to note that the initial, even though they brought it up today, the initial motion was filed on January 26th and was based on the very early version of the rule. The rule has evolved a few times, and much of the language that I think that Complex Products Manufacturing were concerned about was removed. And currently what we see now is, I think, just a statement of fact and has nothing related to hazard on it. And so I believe in my mind that deals with that matter.
I think that's exactly right, Madam Chair. What was objected to was the hyperlink to a website that included information that they were not happy with, and then some language in the actual label. I think, again, as I understand it now, it's a symbol. So not only is the hyperlink gone, but any other language is gone.
Any questions or comments from other board members on that? Any concerns about the particular matter? Okay. So maybe move on to the next item.
All right, so the other two, or the second and third section, which were under the same category of EIB authority, CPMC challenged that various aspects of the rule, saying that EIB did not have the authority to enact a rule that included that sort of language. We heard again in a closing argument today about that same challenge. We've heard from a lot of testimony about the EIB's authority. We heard about it today in closing arguments. So it really is up to the board to decide whether they think that there is a basis for the statutory basis for the EIB to adopt a rule as presented, whether it's in the PFAS Act or the EIA or other statutory authority.
Any questions or comments from the board about the board's authority to move forward on the labeling requirements? I mean, when we go through the rule, we'll talk about that more too. I do want to say that the plain language of the act is clear to me that the board has the authority to require labeling, not obligated to, but we can. Doesn't clearly say that exempt products are exempt from the labeling requirement. I'd also note that I thought Secretary Kenny's testimony describing the legislative process and the amendments to House Bill 212 was illuminating to me too, as far as legislative intent around that. I see a hand up, Mr. Bitzer.
Yeah, I would just concur that we have the authority fairly clearly.
Okay, so then the final was preemption, and this, generally speaking, is the notion that there are certain areas where the federal government has said we have regulatory authority over these things, which preempts any authority by a state. And I believe we heard testimony. Well, we had the position from CPMC saying that certain parts of the rule violate the doctrine of preemption, and we heard testimony explaining how I think the statute certainly has exemptions that are based on recognizing federal preemption, and the rule carries that forward. And we heard testimony on how the department is set up to ensure that when they're regulating, they're cooperating with federal regulators. So again, I'll stand for any questions if there's anything outstanding with the board.
I don't see any hands up, but I also agree that the statute, the regulation, and the testimony by Annie made it clear to me that the federal law, if a federal law regulates a product, the state law would not. And And so I think that deals with the preemption issue. In my mind, is there a differing opinion on the board? Okay, great. I don't think we need to take a vote on that, but I thought that just it was good to have a discussion, as we said we would when we were deliberating. So there are a couple high level issues I thought it would be helpful to discuss before we got into the rules. You know, we don't have a hearing officer's report, and as we've seen in previous rulemaking, it's been very helpful, at least to me, to have a discussion about what some of the high level issues are before we look at the rules. That discussion can help inform how we move forward with some of the proposed changes in the rule. And so one of the big high level issues in my mind is, should PFAS be regulated as a class of chemicals or as individual compounds? I think the case in point that's come forward through testimony was primarily around fluoropolymers. You know, should they be treated differently than other PFAS compounds? Does anybody want to kick off the discussion on that particular item? I do. Is there a hand up, or please go ahead, Member Curry.
As we mentioned the other day, I'm just interested in the discussion of from both sides of the argument on the amount of detail that can be given to the public and by the manufacturer to try to explain what the dangers are or the elements are that are out there by the chemicals. And you know, and we heard the arguments that, you know, if you do it here, you do it in Minnesota or whatever, you're going to have to do it everywhere. But I would just be curious to have a conversation about the detail that we go into. If you compare them to other labeling, whether you're looking at cigarettes or milk or what have you, the detail that we go into, it seems that it would be a good discussion to have, because I tend to find that the more detail, the more data that you have available, the better. So I don't know if that's a kickoff or not, Chairman, or it's just, I tend to lean toward more detail, the better.
Well, I do want to note that the labeling proposal has been simplified from the very beginning, from the petition that was filed to what was provided to us yesterday evening, quite a bit. So there's less detail now than there was in the previous versions of the rule. So essentially now we have the Erlenmeyer flask with the words PFAS in it. And what that would do is just alert the public that there is intentionally added PFAS to this product. It makes no statement regarding the hazards around that. You may recall during testimony, I asked, I think I asked one of the witnesses about how they would educate the public on the hazards of PFAS, because the label was so simplified. It's just a fact. There's PFAS in here. It doesn't say it's a fluoropolymer or PFOA, or it doesn't designate what type of PFAS it is, or discuss the hazards. And the response I got, I think it was from Dr. Chapman, is that they will in the future be looking at a public education campaign to make sure the public understands it. But for our purposes right now, the labeling requirement is really just the Erlenmeyer flask with the PFAS word in it, a little more for complex durable products.
I understand that. I just wonder where the liabilities lie with that statement. I mean, what exposure is there to both the industry and to the regulators to make it that general?
Member Curry, I don't know that we can answer that here. I certainly don't know the answer to that question. And unfortunately, with the record closed, I'm not sure that we have the opportunity to ask that question. So I just wanted to not leave it in silence.
No, and I'm not trying to dig up old stuff, but it's just it still sits out there for me that that what you're trying to communicate to the public, as much specifics as you can give them, you should, and maybe we're past that point at this time, but those are just my thoughts, random thoughts, I guess.
Mr. Bitzer?
I guess I take kind of a different view. I think that you can overdo it to the point where the credibility can be limited, especially since there's such diversity in the actual potential effects, ranging from none to terrible. So I like the flask, it's just a general flag, and then that small subset of the populace that's actually dialed into this at this point can do some additional investigating from there and figure out whether it's one they want to avoid or not. But yeah, I don't see practical room really in the initial communique for detail. That's just my 2 cents.
Member Carrasco?
I guess I'm just of the opinion that if you label something so simple, I mean, on a flask or something like that, or like the flask that you're mentioning, somebody that's working in that kind of a technical field should already kind of know, or if it had some kind of concern. I guess I just think that's kind of a waste to have everything labeled as PFAS. If you're that concerned, you should, and you're in that technical role, you should have already investigated that. I just think by encompassing or like doing an umbrella of all these products, I guess it just doesn't make sense to me. I think that if it's a harmful product, then yeah, maybe it should be labeled with some detail. If it's something that's really, there's no research there and it's not harmful, I don't see any reason in labeling it. And if you are concerned with it, then you should probably do your research behind it.
I would just note that I was somewhat compelled by Dr. Jamie DeWitt's testimony when she said, when I asked her this specific question, if you regulate it by class, is that really based on good science? And she said that she thought that there was enough knowledge to manage PFAS as a class, and suggested that it could be managed simply based on how persistent it is in the environment. And in addition to that, their tendency to bioaccumulate, some with high mobility, warrants managing them as a class. And she's written papers as such, rather than going down to individual compounds. On the other issue that caught my attention was the notion of life cycle considerations. So you might label a product with PFAS or not label it with PFAS because you don't think it's hazardous, but even some of those seemingly somewhat inert compounds can become more hazardous over time if we know about it. And even though fluoropolymers may be considered stable and less harmful, we heard good testimony that if there's incomplete combustion of those fluoropolymers, you can end up with products that or compounds that aren't so safe. And then in the manufacturing process of those fluoropolymers, they still use polymerization aids that can be harmful. The emissions from those can be harmful, and you do get things like PFOA from that. And that was as described by Dr. K for, he indicated that that has been an issue for years. They'd like to move away from that, but they haven't been able to move away from that. We also heard testimony about how there's just so much we don't know about these compounds. You have testing done on a bucket full of compounds, but there are so many more that are in use, and we don't know what the hazards of those are. So you can't really say they're safe. We could potentially say that we don't know whether they're hazardous or not. So what you end up is a big unknown around a lot of PFAS. And so in my mind, considering the life cycle impacts, persistence in the environment, and the unknown hazards around PFAS, to me, it makes sense to regulate them as a class. And I think the labeling requirement is fine. Doesn't provide a lot of detail, doesn't provide a lot of information, but it would at least notify the public if there is intentionally added PFAS in the product. So that's my thinking on it.
So, Madam Chair, here the way typically you shared how a board will typically start with the questions that are in the hearing officer's report.
Right.
Now you're raising this question now. Do you intend to? I think we've heard input from everyone.
Yeah.
Then vote, or just move on and then address it later in the question.
Well, actually, maybe it would be good to just do a thumbs up or thumbs down.
Right.
So I have a sense of what the board is thinking about regulating it as a class, and then pick it up in more detail as we go through the rule.
Okay.
So can I see like a thumbs up from the board members if you think it's okay to regulate PFAS as a class? See Member Curry. Mr. Bitzer, you can say something if you can. I see.
I'll verbalize a thumbs up.
Okay. So, and I see Vice Chair Sweeney has a thumbs up. Member Carrasco, what's your thoughts on that?
Are you saying as a class as a whole, all PFAS, or?
Yeah. Yes.
8 thumbs down.
Okay. So 4-1. And then related to that, the next item I was thinking that'd be good to discuss is related to the labeling, which we, already discussed to a certain degree. As noted by the department in their closing arguments, I do believe that labeling enables the public to modify their risks to themselves and the environment by making informed decisions about whether to bring products with intentionally added PFAS into their home. So I do believe all PFAS products should be labeled. I do also want to mention the whole cost issue, because that's one of the things, cost and practicability is one of the things that as a board we need to consider. I wasn't persuaded by Ms. Marpesi's testimony regarding the astronomical costs related to labeling. In her testimony, she used the Prop 65 analogy, and what California has been through on that. And I do believe the cross-examination was pretty good at convincing me anyways that wasn't an adequate comparison. What happened in California with Prop 65 and what's being proposed. I was also taken by the testimony of Maelstrom. I'm not sure I'm pronouncing that right, but about the economic reasonableness of the labeling requirement based on current literature and his expertise in economics. He, clearly had a strong hold of the issue. This is what he does for a living, and he believed that, to me, he demonstrated that consumers would value and benefit from the PFAS labeling. So I guess the question is, should products that are otherwise exempt from portions of the rule also be exempt from labeling? Do any other board members have an opinion on that? Member Carrasco.
I would agree that if they're exempt, they should be. I would agree that they should be exempt.
Do other board members have an opinion on that? We have a thumbs down from Mr. Carrasco, Member Carrasco, that products that are otherwise exempt from portions of the rule should also be exempt from labeling.
I would give that a thumbs up myself.
Okay.
I don't.
That was Member Bitzer, denoting that he does believe that. State what you believe, Mr. Bitzer. I think I mangled that question.
No, you're right. Yeah, I think they should also be exempt if they're from labeling, if they're exempt from the rule.
Okay, from other portions of the rule. Member Curry, and do you have an opinion on that?
No.
Okay. Member Swayna?
Yes. Thumbs up.
Okay. So thumbs up, are you saying that products that are otherwise exempt from portions of the rule should also be exempt from labeling?
Let's see. Let me think about that.
Okay. We'll get to it when we get into the rule itself.
Just to be clear, it sounds like I'm actually saying they should be exempt, and you give me a thumbs down.
No, so you think they should be exempt. Bitzer thinks they should be exempt. Member Curry passed,
right,
and Member Sweena's thinking about it.
Okay, thanks. I just wanted to.
That's how I take it. Okay, thanks. Yeah. Okay. Are there any other high-level issues the board wants to bring up at this point that you see before we go into the markups? Seeing none, I do have one more, and that came up in the motion filed by ACC, and the question is, does the department have the authority under the Environmental Improvement Act to collect fees for administering rules under the PFAS Protection Act and the Environmental Improvement? And I'd like to kick this off since I brought this item up last week in cross with Secretary Kenny. I was looking for clarity on that issue because, as noted by ACC, I didn't see that fees were specifically authorized in the enabling statute. I reviewed the statement of reasons submitted yesterday by the department and found that to be satisfactory. I also reviewed the department's response to ACC's motion that was filed on Wednesday, which it provided more details to me on NMED's authority to collect fees and under the Environmental Improvement Act to cover the cost of the program. And I received the clarity I needed. I believe those two documents provided good evidence that NME does have the authority it needs to collect fees to implement the program as mandated by the legislature. So I'm just wondering if other members of the board have an opinion on that matter as well. Member Bitzer.
I'd be interested in our council's take on that. Does he concur?
Member Bitzer, so we heard the argument from both ACC and the department earlier today. I think it would be an odd outcome if the legislature enacts a program, delegates the authority to EIB to develop the rules for the program, and then there's not an ability for that program to collect fees for that program to function. So I think there's language in the statute that authorizes the EIB to promulgate rules needed to enable to institute the program. So I think, as we heard earlier today, I think there's authority for with respect to the fees.
That works for me. Thank you.
Any other comments or questions on that?
Doesn't the chairman, Madam Chairman, doesn't the department collect fees in other areas such as this in the department?
Yes, they do.
Well, it seems that that's consistent with what the department has done and what the legislature expects it to do.
Well, yeah, I agree. And when we discuss ACC's Exhibit 7, which is a markup, the proposed markup, we'll go into more details. Mr. Bitzer?
Yeah, that's an excellent point. I've been on the board long enough to remember when we grew the fees substantially for toxic waste permits. Those are $100,000, $150,000, $200,000, $250,000, $500,000 fees, because those environmental impact statements are 10,000 pages long, and it takes years to go through them. But yes, we did that in my first term on the board early on.
All right, I'm going to move this along if there's no other questions or concerns on this. We have 3 markups, one from the department, one from ACC, one from CPMC. And I think we need to go through each of those and have a discussion on what's being proposed. Is that agreeable to you all? See nods, okay. I'm going to suggest we start with NMEDs and move on to ACCs because there's less redlining going on in those two. We can perhaps have a discussion on those first. Does that sound okay? I see no objection. So I'll do that. So if you'll please open NMED's statements of reason in their attachment A. They have a final version and a markup version that I'd like you to open so that we can discuss it. And I'm going to my copy. They actually do have a lot of red ink in theirs, but it's all in one area of the rule, and it's under the labeling portion of the rule, both 20.13.2.13 C and D. And as I noted earlier, these proposed changes greatly simplify the labeling requirements for all products, including complex durable goods. And I would like to just open discussion on this to see if anybody has an opinion on the proposed language changes by the department. Mr. Bitzer.
I just want to make sure I'm in the right document. Is this the one that says attachment A at the top right-hand corner?
Yes, it does. And there's two versions of the rule. One is a
So I go
clean
down.
version and one is a red line.
Okay, I am in the right document then. Thank you.
Uh-huh. And so I'm looking at the red line version and going back to, looks like it's on page 8, where we start the provisions on labeling. Let's start with paragraph C1. And you see the changes there, where they struck both in both English and Spanish. And then they also struck the language regarding the label may include the following words directly adjacent to the flask. This product is made with PFAS, made with PFAS, or contains PFAS. The following wording is acceptable. So they struck all that language in C1 so that it just reads, the label shall be an outline of an Erlenmeyer flask with the words PFAS inside the flask. And then the rest of the language in that paragraph. Yes, go ahead, Member Bitzer.
I see no problem with it. But I'm not the grammarian, so if anybody else sees any.
Member Curry, was that a thumbs up? Thumbs up. Member Sweeney, how do you feel about that? Vice Chair Sweeney, I'm sorry. Thumbs up. Kraska, okay. So thumbs up on that one. Then 2.13C2 strikes the language using materials and methods that are sufficiently durable to remain legible for the useful life of the product. So that sentence would now read, labels affixed to products must be printed, mounted, molded, engraved, embossed, or otherwise affixed to the product. So the requirement that it remain legible for the useful life of the product has been removed. Board members have an opinion on that language? Go ahead, Member Bitzer.
I have no problem with that.
No problem here.
Vice Chair Sweeney? We'll take a vote on the rule when we're done going through this. So we can, there's an opportunity to give a final vote. Vice Chair Sweeney, if you are offline for a minute. Member Carrasco, do you have a thumbs up on that or thumbs down?
Thumbs up.
Thumbs up. Okay. Next, we'll move to C3. Now, this was initially amended in the rebuttal rule where it took out the last, is that one sentence? Last sentence that removed the requirement for the QR code. And so this paragraph now reads, if the product is sold in consumer packaging that obscures the label on the product, then the consumer packaging must also be labeled in a manner that is compliant with C1 of this rule. And then the removal of the requirement to have the QR code or link to the website. So in, go ahead, Member Bitzer.
That works for me.
Other members?
I'm good.
Good.
No issue.
No issue? Okay, me too.
So
Thank you. Thank you, Member Sweeney, or Vice Chair Sweeney. And the same with paragraph 4, that was amended earlier, not just in this proposed final rule where they remove the last portion of that sentence, which it requires a link to the internet. This is for products that are on sale, online sales. For online sale products.
Looks good.
Are you okay with it? No issue? Okay. Member Sweeney, Member Curry? Okay, good.
Madam Chair,
Yes.
if I could ask a question.
Yes, please.
So, sorry, Edmund, could you confirm that this is a cumulative red line, including the prior rule? Okay, thank you. I think I missed that when I looked at it. Thank you.
So now we're down to section D, so that's 2.13D, labeling of complex durable goods. As you all may remember, there was a fair amount of discussion on this during testimony last week, and we even brought Dr. Chapman back to help us understand what was in this, and they've since made additional changes to the proposed labeling requirements for complex durable goods. So the first change in D strikes in the second line of or components that contain intentionally added per- or polyfluoroalkyl substances. And so now reads labeling of complex durable goods with intentionally added PFAS substances, that's the title. And now reads prior to sale of a complex durable good that contains intentionally added per- or polyfluoroalkyl substances, the manufacturer shall conform to the information requirement of this section. Mr. Bitzer?
Two things. One, I'm good with that, and then up above in number 5 of C, they had added, at least in my copy, it's red ink there. It says in writing, and I'm all right with that too.
Thank you. It wasn't underlined and I'm looking at a black and white copy. So So it is in red. So let's go back to that. The manufacturer shall apply any product and package labels required under this section unless the wholesaler or retailer agrees in writing with the manufacturer to accept responsibility for such application. So you're okay with that, Mr. Bitzer? I'm okay with that. Member Curry? Good. Member Sweeney? Good. Okay. All right. Good catch, Member Bitzer. Thank you. So Member Bitzer was okay with the changes in D, the header paragraph which eliminates or components that contain PFAS. I'm okay with that too. Member Curry, members, Vice Chair Sweeney. Thumbs up. And Member Carrasco. Okay. So now D1 has a lot of red on that. And that's where we had a fair amount of discussion last week. It appears to me to be greatly simplified. I'm not going to read what's been eliminated. I'm just going to read how it currently would read in the rule if we were to adopt it. It says a label indicating the presence of intentionally added polyfluoroalkyl substances shall be included in the consumer-facing product specification sheet available to potential consumers prior to purchase. And then goes on to say the label shall be an outline of an Erlenmeyer flask with the word PFAS inside the flask. I think those are good changes that address some of the concerns from Complex Products Manufacturing Coalition.
I would agree.
So you're okay with this, Member Bitzer?
Yes, indeed.
Members Curry, Vice Chair Sweeney?
Yes.
Okay. Member Carrasco? Okay. They struck 2 in its entirety. So D2 has been removed and they amended the sentence formerly known as 3, now 2, to say the label must be easily identified and legible on the consumer-facing product specification sheet. A 10-point font or larger is presumed to be legible.
Legible unless you're my age, in which case you need readers. But yeah, I'm good with that.
Okay. Member Curry?
Comment? I have no comment.
No comment? Okay. Members
To
Sweeney?
Barry's comment, I have no comment.
Oh, yeah. Yeah, 10 point is pretty small for me too. Are you okay with the language change, Member Curry?
Yes.
Vice Chair Sweeney? Yes. And okay. Getting down to 4.
What's the TIF do?
The
The
new
TIF isn't due for another, let me find that.
Vice Chair Sweeney? Vice Chair Sweeney, are you saying addressing
Yes.
the group? Okay, go ahead.
No.
Oh, okay. Thank you. The now D3 now reads the consumer facing operation and maintenance manual associated with the complex durable goods shall include a label as described in 20.13.2.13 D1 of this rule, indicating the presence of intentionally added PFAS. The big change here, as I see it, is they eliminated the requirement for a complete list of components with PFAS, including the location within the complex durable good, such that it can be easily located. That's a big change from the previous proposal by the department, and I believe also in response to the CPMC. Do we have an opinion on that language? Go ahead, Member Bitzer.
I'm good with it.
Good.
Good. Chair Sweeney, or Vice Chair Sweeney? Okay, great. And then D5 has been eliminated completely too, which would require product information in language other than English and Spanish. So that's been eliminated, and again, greatly simplifying the requirements for the labeling of complex durable goods. You guys okay with eliminating that language? Thumbs up from Carrasco, thumbs up from me, thumbs up from Curry, Sweeney,
Yep.
Member Bitzer, and Vice Chair Sweeney. Okay, great.
Madam Chair,
yes.
Because you're working on a document copy, I'll commit the mistake. Subsection
Oh.
B has a color.
Oh, thank you.
Your name, sir.
Okay. All right. Thank you for that. Can't afford color copies. Yeah. So there is this the last change? Okay. So there is one more change, and that's in 2.13 E, paragraph E, and it says, and this is related to consistency with other states. Some language has been added such that it reads, the manufacturer of a product with intentionally added PFAS may comply with the labeling requirements of this rule by labeling all units, or as applicable, consumer-facing specification sheets and consumer-facing operation and maintenance manuals of the products sold in New Mexico in compliance with corresponding requirements in another state. It seems like a consistent addition, an addition that's consistent with some of the previous language that we discussed.
I would agree.
Yep. Other members? Thumbs up from Curry. Thumbs up from Sweeney.
Yeah, I'm good. You do have one other red. That's a real small one on number 938, but it's just changing the 4 from a 5 to a 4.
Oh yeah. Okay. Yeah.
I didn't show up on yours.
Yeah. Thank you. I don't think we need to discuss that. Yeah. Okay. All right. So we've completed the markup of NMED's proposed changes. And so anything else that we're missing on this that any other board members can see? Okay, so it sounds like we're in agreement with simplifying the labeling requirements as proposed by NMED. I'll move on to some of the other parties. And I was proposing that we move to ACC's exhibit, I believe it's 7. Oh, shoot. Let me just take a minute to find it. Go ahead, member or council.
So, Mr. Mullenberg, I see that there's ACC Exhibit 7 is in what was filed yesterday, the proposed statement of reasons. Is that the entirety of what was proposed when I think in the NOI or the rebuttal NOI, you produced the full red line of the rule? Is this, should we be focused on what was submitted yesterday or the original?
Yeah, just for that clarification of the documentation. If you just use the NMED Exhibit 7, which was filed yesterday with the statement of reasons, that covers everything that ACC is proposing as changes. There was an earlier, I think it was ACC Exhibit 6. I think it also just kind of took the excerpt approach rather than repeating the whole rule. But yeah, Exhibit 7 has everything.
Yes, page it.
I think we all know what we're talking about, but my colleague said I may have said NMED Exhibit 7. I, of course, meant ACC Exhibit 7.
If I'm looking at the right doc,
Yeah, we're just getting oriented here. So yeah, it was attached to their statements of reasons, ACC Exhibit 7. And the
looking at
title of
basically
it,
a one.
go ahead, Member Bitzer.
We're looking at basically a one pager, right? ACC
Yeah, well,
Exhibit
too, if you
7.
flip it. Yeah, there's language on the backside too that needs to be considered.
Got it.
Oh, thank you. Do you all have that in front of you now? Members on the platform? Do you have Exhibit 7, ACC's Exhibit 7 in front of you?
I do.
Member Curry and Vice Chair Sweeney? Okay, thumbs up from Sweeney. Member Curry, are you there? Pam, is Member Curry still on the platform? Oh, there he is. Okay. Member Curry, just making sure everybody has Exhibit 7. Is it in front of you now? Right. I can read lips. He said yes. So the first proposed change is in the title, and that is to strike the word fees. You'll see on the back of this one pager, they're proposing that we remove all language related to fees. And so I'd like to get board members' thoughts on that. We had it. Go ahead, Member Bitzer.
My recollection, there was general consensus that we have authority to do the fees, and so I would reject the dropping of the word fees and the dropping of the language it's related to.
Thank you for that. Other members, do you agree?
Definitely.
Member Sweeney, thumbs up. Member Carrasco.
Agree.
Okay. So we'll reject that change. The next change is to strike the definition of consumer. And Mr. Mullenberg mentioned this in his closing argument. Is there a census? Board members, I'm just wondering how you feel about that. I do want to note that when we get to excuse me, CPMCs, they have a proposed language change to that definition. But ACC is recommending that we strike it in its entirety. The term consumer is used throughout the rule, so I think it would be helpful to maintain some kind of definition of consumer. Council.
Yes, Madam Chair, just to point out that the term consumer is used in the rule. So if it is struck, if the definition is struck, then you'd have an undefined term. It would take more work in the document.
Member Carrasco?
Thank you, Council. I think that of what I feel about it.
So Member Carrasco, you support rejecting this
Yes.
strikeout? Member Bitzer?
I would agree, and we can revisit this when we look at the third set of proposed changes.
Member Curry and Member Vice Chair Sweeney?
I completely agree with Member Bitzer on the review back.
And Vice Chair Sweeney concurs, so that we will reject that change. The next change is was also brought up during closing arguments, and it's in 13.2.10 under exemptions. And what it does is it adds reference to 20.13.2.9 as one of the exemptions for exempt products. So currently, exempt products are exempt from reporting and testing, and the CCU provisions of the rule. This would add 2.9 as another exemption, and 2.9 is, if you want to look back in your rule, it is the provision related to prohibitions. To me, it doesn't add any clarity to the rule. I think it actually adds some confusion to put 2.9 in there. So I would propose that we reject the addition of that language.
I'll concur on that.
Concur.
I don't have an opinion.
And Chair Sweeney, okay. So 4 members think it's okay to not accept that. The next proposed change is under labeling, 2.13, and this was brought up in both closing arguments for ACC and CPMC, and that is changing the date for the labeling requirement from January 1, 2027 to January 1, 2028. We give them 1 more year to come into compliance with those labeling requirements. Is there opinion of the board on whether to accept or reject that?
I would accept.
I concur. I like this change because I understand the supply chain, the lead times, the processes, the existing inventory, all that kind of stuff that we heard. And my business background, I've seen that borne out. So I would give them the extra year.
I just want to note that during testimony, I asked Dr. Chapman about this particular issue because there was concern during technical testimony about the ability to meet these deadlines. And he pointed to the I think it was the waiver provision that said that if they file by October 31st, 2026, that it will be considered an approved waiver. And the department needed to make a decision by June. So he was implying that there are provisions in the rule that would give the companies more time should they need it under those provisions of the labeling requirement. So I may be less inclined, but I'd like to hear from other parties. Is that Member Bitzer? Yes, go ahead.
Business relies on certainty, and that version of a waiver version enters an element of uncertainty. We're not a big state. We're not an important market compared to a California. So I mean, if California says that you got to do this, it's like a country. But New Mexico's what, 1/18th the size. So did I get that right? Yeah, about right. So I would rather give them the certainty and give it to them in writing that would give them the extra year.
Vice Chair, thank you for that, Member Bitzer. Vice Chair Sweeney and Member Curry.
I guess I'm lending back again into detail versus a whole round of considerations about the detail and we talked about that earlier. You know, if we're going to give them an extra year, does that give us more detail? It doesn't. And so I'm conflicted at this point. You know, I understand what Member Bitzer said about clarity and certainty. I think that's very, very important. But I'm also concerned about just delaying the whole process.
Vice Chair Sweeney, do you have an opinion on whether we should move the date for the labeling requirement from January 1st, 2027 to January 1st, 2028?
Can you hear me?
Yes, go ahead.
Sorry about that. Well, my comment is I want to be really mindful and careful of changing the date. I know we ran into making sure that the dates align. If there's any consequences to the overall general rule, I just want to make sure if we do change the date from the department's proposed date, that we don't have any collateral dates that might be dependent upon the initial date. So give me a few minutes. I'm going to look through the proposed rule, but if any other board members, including yourself, Chair Ely, see that there might be issues with that, I just want to make sure that we're consistent and that we consider that.
Yeah, that makes a lot of sense. You know, we can also come back to this when we look at CPMC's proposed language because it's similar or the exact same. So we have a little bit of time. We can defer this for right now if that makes more sense.
Yeah, in the meantime, as we get there, Chair, I'll keep looking at the proposed rules.
Okay, so I'm going to note it as an outstanding question. All right. The next labeling suggestion is to add a fifth item that is exempt from the labeling requirement. See, right now there are 4 items that are not required to label, and those are used products, that are subject to the Federal Insecticide, Fungicide, Rodenticide Act, veterinary products, and medical devices. This would add products listed in 20.13.2.10. And as you probably recall, that is all the exempt products. And this is a point that came up many times during testimony, in the statement of reasons, and in closing arguments today. So the big question here, which we discussed briefly a little bit ago, was should products that are otherwise exempt under the rules also be exempt from the labeling requirements? I'm going to fill the slide. Go ahead, Mr. Bitzer.
I would reiterate my my yes to this one. Just I like the idea that we're being consistent. If they're already exempt, then yes.
Other members? During the previous discussion about regulating PFAS as a class or as individual compounds, I think my opinion came through that even exempt products should be labeled so that the public can make an informed decision about the type of products that they bring into their home. So I would reject that language. Member Curry, Vice Chair.
I agree. I agree with the chair.
Other members?
So I agree with leaving exempt as it is, so this would actually cover that. To include those as well.
Say that again.
So the exempt products that this is basically saying that, so to add this to include those exempt products or to omit those exempt.
That's right. So products that are exempt under 10 would not be subject to the labeling requirement if we accept this language.
I would accept this.
Okay. So, and then we just need to hear from Vice Chair Sweeney.
Yes, I agree. I agree.
You agree to accepting or rejecting the language as proposed to add in a 5th item that is exempt from labeling? Chair Sweeney, or Vice Chair Sweeney, I don't mean to press you. It's just one of the more important issues around this ruling is whether those items that are otherwise exempt have to be labeled as containing PFAS. Vice Chair Sweeney, we can come back to this. Right now the board is split, but this is also part of the language that is in CPMC's proposed rule changes. While we contemplate that, we can take a break. I think we've agreed that the language on the back side of this proposal regarding fees, we would reject because we believe the department has the authority to collect fees and they need to collect fees, but we can discuss that when we return from our break. So 4:10? 4:05, we'll be back at 4:05.
If you're a calling user, could you identify yourself, please?
Hello?
Uh, yes, your name, please.
Hi, Alicia Chinkota. I'm with ACC.
Okay, thank you very much. Vice Chair Sweeney, are you on the line? Is there another calling user that can identify themselves?
I'm on the line, Ron Curry.
Oh, thank you, Member Curry.
I'm
Madam
here
Chair,
too.
I don't think it's Vice Chair Sweeney.
Just so you know, we're trying to connect with Vice Chair Sweeney. Her internet is down. We're hoping we can connect by phone.
While we're working on that, can I inquire as to how late we think we might be going?
I think we're going to certainly go till 5. We cannot really go much past that because we'll get kicked out of here by the guard.
I'm expected in Old Town at 6:30, so I just wanted to make sure we weren't going into the night.
Oh no, we'll be out of here before in good time for you to make that appointment. Okay, so let's try to get through as much as we can while we continue to try and connect with Chair Sweeney, because we, like I just noted, we cannot be here much past 5. And so there's a few outstanding issues right now, and one is the date for the labeling requirement. We need to come back to that, and we will with CPMCs. And the other one is adding a 5th item to products that are exempt from the labeling requirement. We've heard from all the board members except for Vice Chair Sweeney. So we'll have that discussion once we get her on. And then if you wouldn't mind just turning the page on ACC Exhibit 7, which suggests omitting sections 15, 16, 17, 18, 19, 20, 21, 22, and 22 from the rule because those are all related to fees. And I think we made a decision, unanimous decision, that the department should be collecting fees. So let's then move on to CPMC's proposed language. And that is also labeled attachment A. That was part of their submittal that we got yesterday evening. And the first change they are suggesting is the change to the definition of consumer. And they are suggesting we change it so that it reads, consumer means one who seeks or inquires by purchase or lease any consumer product as that term is defined in Section 2 of the PFAS Substance Protection Act 74-15-2 NMSA 1978. As you recall, ACC suggested striking that in its totality, and CPMC is suggesting that we just change the definition and reference the enabling statute on what a consumer product is. How are the board members feeling about that proposed change?
Legal anyway.
So it's I don't think the struggle that certainly that I've had is that the document that CPMC submitted along with attachment A has called for a different revision to this definition. So we don't have anything other than the revised language. From a legal perspective, I don't really see, there's not really a material difference between the itemized list that was in the definition, the original definition, to just saying anyone who buys such and such. And so I just don't see a difference, certainly from a legal perspective, in that change. And the last part of it, making reference to the statute of consumer product, that seems to be consistent with what the statute says. So there's no legal concern with that. No, I'm not sure if that's helpful.
Yes, sir. Thank
So counsel, you're saying that the term one would encompass individual, partnership, corporation, state agency, or subdivision, or agency of the state?
Well, I just think so from a legal perspective, if the sentence originally read, consumer means one who seeks or requires to purchase something. And so you go from, then you change the term one to an itemized list of an individual, partnership, corporation. It's still something is buying something else, whether I have an itemized list or one. There doesn't seem to be, certainly if any of those entities, a corporation or a state agency purchased, they would be a consumer in the original definition. And I think if it was revised to refer to as one, if a state agency purchased or seeks to acquire or by purchase or lease any product, it would be a consumer either way.
So it doesn't really add anything or change anything?
No, I don't, that's why I guess my way of saying it, there's no legal difference, is it doesn't really, it just certainly doesn't add value by converting it to one.
Okay.
I think the end of that phrase, the definition where they convert goods and services to the definition of consumer product, that seems to be consistent with the statute because the statute is focused on consumer product. So to say that it's a consumer who's buying a consumer product is certainly consistent with the definition.
Member Bitzer, you have your hand up.
Yeah, actually, I like the change. Rather than doing the inventory, the listing, you throw a broader net potentially too, in case there's something we forgot, some type of legal one that we're not thinking of, or that you could percolate up later. It's a broader net and uses fewer words, and then the consistency at the end too. I think makes this a good change.
And I apologize. I should have said consistent. The end of the definition has been revised to be consistent with the statute. So I apologize for that.
No, that's
Go
what
ahead,
you said. I just paraphrased it badly.
Member Curry,
I'm fine with the change.
Member Carrasco.
I'm okay either way.
Okay. All right. So I guess we'll accept that change now. We don't have, well, we do have a quorum because there's 4 of us here. We don't have Vice Chair Sweeney at this point, but we can, I think, accept that change. And if we have time, loop back to it.
So, Madam Chair, you're saying you're agreeing with the change.
I'm hesitant to make the change because I'm not quite.
Oh, you're hesitant.
Yeah,
Okay.
I'm not quite sure how it would, the ramifications elsewhere in the rule on this, kind of what Vice Chair Sweeney was talking about related to the date.
Right. Okay.
But if we have 3 members that are okay with it, then the board's okay with it.
Okay.
Yeah.
Thank you.
The next language change is to add a definition for watercraft, and that's down at the bottom of the page there. And what that would do is it would add language that says watercraft means any contrivance, I would say device, but used or designed for navigation on water, including but not limited to any vessel, ship, boat, motor vessel, personal watercraft, steam vessel, vessel operated by machinery either permanently or temporarily affixed, motorboat, sailboat, barge, tugboats, and rowboats. I don't think we have tugboats, but that's as that would read, a definition of watercraft. Watercraft is used elsewhere in the rule, so I don't have a problem with that adding a definition of watercraft personally. Do other members have an opinion on that?
I'm okay with it.
Member Bitzer?
They forgot kayak and canoe.
Yeah.
And dinghy. And Zodiac. No, I'm good with it.
Yeah, well, it does say including but not limited to. So we'll put dinghy and kayak in there under that portion of the definition. Member Curry?
I know there may be a long and again another crazy question is what about airboats that are frequently used on the Rio Grande when there's water there for safety purposes?
Yeah.
Where do they fit in?
Part of the used or designed for navigation on water, including but not limited to language, I think. So the first part of that is all encompassing, and then they get specific about what watercraft specifically would come in this. So I think it would cover that, yes.
Okay.
Member Curry.
And not balloons that go into the river for splash and dash.
Just yours. Yeah, no, not balloons that go into the river for splashdowns. So, where are we? So, Member Curry, you're okay with adding a definition of watercraft as proposed?
Yes.
And Member Carrasco?
Yes.
Okay, so accept that one. The next proposed language that I see in my black and white version is under exemptions, and that's in G. And so they're suggesting that, and they're adding language to it, to the end of that, that says, and is not covered by subsections A or L of this excuse me, I'm just looking back of this section, and then goes on to say textile articles contained in motor vehicles that require the use of intentionally added PFAS substances to meet federal motor vehicle safety standards are exempted by subsection A of this section. Council, go ahead.
So, Madam Chair and members of the board, so here, if you look at A is a general exemption that essentially says that if a product is governed by federal law, then it's exempted from this rule. Then there's a few of these subsections, including G, that talks about a motor vehicle, and it makes reference to a specific federal statute or a code program. CPMC here is proposing, and I would imagine it's the Automotive Innovation Group, but in their joint proposal, they're submitting some further clarification to, in this instance, the textiles and that are used inside of a car. I recall the board hearing testimony with respect to how the preemption program works at NMED, and the idea behind subsection A, that first paragraph, which is this blanket statement saying that if something is governed by federal law, that with respect to PFAS, then our rule doesn't apply.
Right.
We did hear testimony from a few parties that they were concerned that the language wasn't explicit. And I suppose this is some attempt to make that explicit. One caution, which has been brought up before, is that when you start making changes to language like this, you have to be mindful of the cascading consequences, and so that I just remind the board that.
Thank you for that explanation, and I think paragraph A covers that whole preemption issue, and that we don't need to specify any further in these exemptions. And I feel that same way when you get down to watercraft that are covered by federal regulations. That, we've got the catch-all in A that says if there's federal law, that the state doesn't have the authority to regulate. And rather than be specific anywhere, I think we should just reference paragraph A of this section and not accept language that would move us in a more specific, to more specific language. Member Kraska, you agree? Okay. Member Curry and Member Bitzer.
I'm good.
Okay. So we'll reject that language in G. The next proposed change is in H, which would add low speed personal transportation vehicle golf car. It probably means golf cart. To the list of vehicles that are exempt. And I don't think it's needed. Yeah.
Right. I think, just so, Madam Chair, I think you pointed out this before in a different example, but the H begins with any other motor vehicle.
Yeah.
And so it really is up to the board to decide whether it should be as specific as they're trying to be, or it's captured in original language. I think the member Bitzer school of thought was the fewer words are better.
Yeah, and if there's a question about whether their golf cart is in an exempt or not, I think that's a guidance document. And you know, it could be even broader than this. Is my mother-in-law's wheelchair exempt? You know, so I would support not adding more language.
I would agree.
Okay. Member Curry?
Good.
Agree.
Okay, great. And then in they add language around watercraft, and it says, so it would read, a watercraft, marine accessories, and marine equipment regulated by the Federal Boat Safety Act, 46 USC 43. And per our previous conversation, I think items that are regulated by federal law would be covered under paragraph A, and that we don't need to add items to this list. So I would reject that particular language.
Agreed.
Member Curry?
Agree.
Member Carrasco?
Agreed.
All right, moving on. So we're moving out of exempt products and going to currently unavoidable use. This was in the first proposed change in 2.11 A4 is under subsection paragraph I, kind of wanting to limit what is reported or what is considered under currently unavoidable use. And I would reject first, and this is on page 13 of the statement of reasons or justification for this. And I would just note that I think what we do really want is both the how the PFAS is used and the standards they are meeting. And so if we accept their language, we would only get the standards they are meeting and not the PFAS that is being used. So I would suggest that we not accept that under the CCU requirements. CUU requirements, sorry.
I would agree.
Agreed.
Member Curry?
Agree.
All right, then the next proposed language change under the CUU requirements is related to confidential information and trade secrets. And they are suggesting, well, you could read the proposed language, but it would say, if we accept their language, that should a proposal for a currently unavoidable use determination contain claims of trade secrets or confidentiality, the department may evaluate and determine whether there is sufficient publicly available information to support a final determination on the proposal. I don't think that in my mind is strong enough, and I would reject that. It's just kind of a flip of the current language. We did have some testimony on trade secrets, partly at the prompting of Vice Chair Sweeney in her cross of Secretary Curry, but not a lot. How do you read that, Member Carrasco? I see your brow furrowed.
I'd agree with you.
You agree we should reject that language? Member Bitzer and Curry?
I concur.
I agree with the chair.
Okay. So moving on to 2.12, which is the reporting requirements. They marked B3 to, and I tell you, I looked at this and was kind of confused as to why this was in here at all, because there was no testimony on this, and I didn't see anything in their NOI on changing this language in their SO statement of reasons. They say they were trying to align with the state of Minnesota. But because we didn't have an opportunity to have a discussion around that or question CPMC regarding these changes, I don't think we should consider them. It's almost like getting a second bite of the apple when they come in at the last minute with some proposed changes that were not discussed during the technical portion of the hearing.
Yeah, I would agree.
Member Curry, Member Bitzer?
Agreed.
I agree.
Okay, now we're getting back to labeling. So, in labeling, once again, there is a proposal to change the date from January 1, 2027 to January 1, 2028. That is consistent with what was proposed by ACC. We had a little bit of a discussion on that, and we're kind of deadlocked since both Member Curry and I think the date should stay the same, and Member Carrasco and Member Bitzer are supportive of adding, providing them another year on that. I'd really like to have Chair Sweeney available to have this discussion. So I'm hoping she'll come back to the hearing and we could have finish our deliberations on that point. To me, I get it that industry needs would like more time to deal with the labeling issue. I do feel like the changes made by the department to greatly simplify the labels will make it certainly easier for industry to comply with this deadline. I also note that, the labeling is part of educating the public. And so at the same time, this date coincides with the same time that the prohibitions kick in. And I think there's some synchronicity to having those coming out at the same time. So in my mind, it's another reason to maintain that date of January 2027. That being said, I'm not sure that we can move on this until we see Chair Sweeney. Yeah. Yes.
So actually, Member Bitzer, you earlier when this subject was discussed, you made some comments about certainty for business. Was that concern in factoring in the new label, which we reviewed earlier, is essentially the flask with the word PFAS in it?
Yeah, I mean, but the exemption that they would have to apply for is not a guarantee. So it builds an element of uncertainty. I also had concerns about the lead time. Some products have a long lead time, or they might sit on a shelf. You have a boat that doesn't sell it for a year or two or whatever. So it's just, I mean, that's an extreme example, but there's a lot of things that aren't just in time inventory, if you will, JIT, as they say in business school. But but yeah, so I've got a number of concerns about that date. And I get that the simplified labeling helps, but it doesn't completely ameliorate my concerns.
Okay, thank you.
Yeah. So, yeah, that's on my list of outstanding issues that really can't address without Vice Chair Sweeney as part of this deliberation. So then the next proposed change in CPMC is dealing with labeling exemption. And you'll see they're adding a new item 2 there. It says adding products that are exempt as specified in 20.13.2.10 of this rule, or that have been designated as a currently unavoidable use pursuant to 20.13.2.11 for this rule. And so that we've had a kind of a brief discussion about that earlier. This is added to that, where it's not just products that are exempt in 10 that would not be subject to the labeling requirement, but also products that are have a currently unavoidable use designation. And per our previous conversation, I'm not sure we can make progress on that. As we discussed earlier in ACC's proposal, I think Member Bitzer and Carrasco were in favor of allowing these items that are exempt in 10 to also be exempt from labeling. And Member Curry and I had a differing opinion on that. This does add currently unavoidable use products that have currently unavoidable use PFAS in them to also be exempt. That's a little bit new. And my position on that stays the same, that if families are purchasing products that contain PFAS, they should know it, even if it is an unavoidable use. They may not purchase that product. They may make different decisions about how they dispose of that product. So I think in trying to be transparent with the public, we should require those to be labeled, but I realize that's just my opinion.
Madam Chair, just as a reminder, the board began the deliberations with the discussing a few high-level questions.
Right.
And the second question that you asked was, should the products that are otherwise exempt from portions of the rule, reporting, testing, the CUU. So my recollection is that the board took that up and answered that. And we did have the 5 members giving their opinions on it.
Sure. That's true. But I also would like Vice Chair Sweeney to weigh in on this particular language. Madam Hearing on. All right. Moving down, there's a few more suggested exemptions from the labeling requirement. 6 is for motor vehicles. 7 is for watercraft and marine accessories. 8 is for products with PFAS that are currently listed as acceptable subject conditions or acceptable subject to narrow use by the United States EPA, which would be the SNAP stuff, under the significant new alternatives policy programs, provided that the product contains PFAS substances that are being used as substitutes for ozone depleting substances under the conditions specified in the rule. And then 9 is a product consisting of polymeric substances for which the backbone of the polymer is either a per or polyfluorinated carbon only backbone or a perfluorinated polyether backbone that is solid at standard temperature and pressure. I would suggest that we not add 4 more items to this list of items that are exempt from labeling. The board may move forward with products that are already exempt from labeling or CUUs. I don't know. I don't feel like we need to add 4 more additional things. But I'd like to hear from the other board members.
I don't know how many seaplanes we're going to sell in New Mexico. I'm not sure we've ever sold one here, at least not new.
Yeah. I do want to point out that some of these things, you know, would if we vote to accept the changes to include exempt items that are in 2.10 as exempt items or items that are exempt from labeling, that would include, you know, motor vehicles and watercraft and fluoropolymers. I mean, it all, you know, that goes back to that. So back to 210. And so I would suggest that we reject those 4 items.
I would agree, subject to actually approving 210. So
I would agree with number
as well.
Okay, so we'll reject those for now.
yes, for now.
Yes. So now moving to 2.13 D, there's a number of changes here. I like what we did with the departments portion of the rule. I don't suggest that we tinker with D since this conforms with what is in D. And I think that we just, and uses the same terminology, consumer facing complex durable goods. I believe they stated in their statement of reasons that the department was supportive of this language. And so I suggest that we just accept the department's draft on the language in D.
I would agree.
Agree.
Member Curry?
Yes, I agree.
All right. All right, so then we go to E, consistency with other states. And once again, we accepted NMED's language on that. So I suggest that we just not move any further on that and move on to the next item.
Agree.
Agree.
Member Curry?
Just for clarification, how many are other?
Where are you looking? What do you mean by other, Secretary? Or
How many,
Member Curry?
what's the number? Is it 2 or 3?
I'm lost, Secretary. Number of what?
maybe I'm misinterpreting what I'm thinking about here. Is it other states that are trying the same?
Oh, I see. Yeah. Okay. So we had testimony from Secretary Curry on that. He had 22 other states that were considering some type of regulation, a few of which, you know, maybe more aligned with ours, like Minnesota, Connecticut, Colorado. So I say, when you say consistency with other states, and that is now, you know, there's movement, there's more states that are moving forward with regulations. So we know there's at least a few and potentially more in the future. So that's my understanding of consistency with other states. How many other states? That's what my recollection is of the testimony we got last week.
Okay. It just seems a little vague.
You're okay with accepting the department's proposed language rather than making okay. And then the department didn't propose striking 1 and 2, but I think those below E1 and E2 as CPMC is, but I think those are essential if we are going to be consistent with other states, that those states should provide a copy of the label and other specifications around it so that they can determine whether they can accept those other labels from other states. So I suggest we reject the language in 1 and 2.
I would agree.
All right.
Okay.
Okay. Moving on to F. So this is the waiver language in CPMC's earlier proposed draft. They recommended striking this in its entirety, but have backed off on that and are proposing some amendments that would expand the sources or the products that could apply for a waiver. So by striking, if the product is exempt pursuant to section 20.13.2.10 of this part, would not just limit this waiver to exempt items, but would broaden it. That's how I read it. Is that how you read it, Council?
Yes, Madam Chair.
And none of the products, they would also strike none of the products, materials containing intentional PFAS will ever come into direct contact with a consumer while the product is being used. So I think both of those items are safeguards and would support not striking that language and leaving that in for manufacturers applying for waivers.
I would agree.
Agree.
Okay, so we'll reject that. All right. Moving on to 2.14 in testing. Again, some of this language we also did not hear anything about during testimony or in the NOIs, and so I don't think we should even consider some of this language. That first paragraph under testing, that first sentence, you know, it is a little bit of semantics. To strike, there is reasonable suspicion to the department has reason to believe. I would propose not making that change because I don't think we should be messing with those semantics there. Do you agree?
Yes.
Member
Indeed.
Gibson? Yeah, Curry?
Indeed.
Okay. And then this whole paragraph B1 is another example where I feel like we had no direct testimony on this. There was nothing in the NOIs about changing these reporting ranges. So I don't think we should take it up. It seems like another bite at the apple when they could have brought this up much earlier for our consideration so that we could at least ask questions about it.
Agree.
I concur.
Member Curry?
Yes.
Okay, thank you. And then, there's some cleanup here that I don't think we have to address. Some of these words were kind of run-ons. They just put spaces in them. And the information is prohibited. That's cleanup that the department will do with the records center. So we don't need to discuss that, in my opinion. And so I would support moving on to some of the next edits. Are you all ready for that?
Yes.
Yep.
All right. So the next edits that we see are similar. And point 17, currently unavoidable use designation application fees. Again, it's more cleanup for the record center and the department because some of these words are run-ons and neat spaces and really don't change the meaning, but certainly are typos and should be corrected, and I have no doubt that they will be. So I suggest that we not do anything with that and move on to more substantial edits.
Chair, you going past the 8? That's a
Oh, did I miss something?
has a fee change.
Where is that?
A, it's on 2013 to 18.
18.
A.
A.
Oh, okay.
You were just in 17.
Haven't gotten there yet.
Okay, sorry. I was just looking at all the further ones that were just
You're way ahead of me, Member Carrasco. Yeah. No, I was just looking at those kind of typos. And the same with the beginning of 18 where it says furthermore, but the fees, yes. Now we didn't get, I don't think we got testimony on that, but we did discuss fees. They had some statements in their statement of reasons regarding fees and what was needed for the program. So yes, let's have a conversation about those fees. A suggests changing the fees for currently unavoidable use from 5,000 to 2,500. And there are further edits to those numbers down in the schedule of fees for currently unavoidable use. Yes, Council.
So, Madam Chair, what I see in A is the revision of 5,000 to 2,500.
Yeah.
And then in B from 2,500 to 500.
Yes. That's right.
And 18, those are the material changes that I noticed.
Yes. Yeah, the others are not material changes. So I think the department secretary Canny made a good case about the fees that are required to run the program. And the calculations may be rough, but because the program is not up and running, but they've certainly talked with plenty of other states about what it takes to get a program going and to maintain it. So I would suggest not changing, dropping those fees in A or in B. And I'd love to hear from the other board members.
Agreed.
I would agree.
Member Curry?
I agree. You know,
Yeah.
I agree. I just always think that fees are an interesting subject that can spend a lot of time talking about. And fees are a generator of a lot of different things, but I agree. I won't go into any more detail than that.
Well, we'll have plenty of time to talk about air fees in the next hearing. So
Yeah.
save your fee ambitions for that next hearing.
I will. Thank you.
Yeah. All right. So we're through. I mean, there are a few other edits here in C that, again, those are just edits and typos. We're through except for the two major issues. And one is the date of the labeling requirement and whether exempt products should be also exempt from labeling. So I'm going to pause for just a minute, have a conversation with counsel and the hearing officer about how to move forward with our fifth member. All right, so I really do feel like we need Vice Chair Sweeney to weigh in on those two very important issues. And we were able to resolve everything else with a consensus, a 4-0 vote, but we're kind of locked on those. And so we're going to have to think about another time to have this discussion because I don't anticipate her coming online anytime soon. And she's trying. She's trying. She knows how important this is. So I have a question for the board members that are here. If we have a couple options for getting together again to discuss those two items, and one option is next week. We will need a 72-hour notice, correct? Counsel and Madam Hearing Officer. And so we could meet, is it 72 working days? The weekend doesn't count. No?
It's 72 hours.
So we could consider the weekend if we got something up. Okay. But Madam, go ahead.
Tuesday is out of the question because the staff will be supporting the WQCC.
Okay. So we could go near the end of the week, Thursday or Friday.
Yes.
Okay. Or I could even do Wednesday. I'd have to change an appointment. Of course, we have to check with Vice Chair Sweeney on the days. But do we have any availability from the board members that are currently here for Wednesday, Thursday, or Friday next week?
I'm open any of those 3 days.
Okay.
I can't give you anything definitive because of travel.
Okay. That's okay. We can look at another time too. Member Curry, we want you to be there. Yeah. Now, as I noted earlier, we have another hearing coming up. And that begins on Monday, the 23rd. That's for air quality fees. So we're going to be getting together then. We'll have the hearing officer, we'll have our support team, and David and others. And so that might be the most convenient. I think Chair Sweeney, of course, has stated she would be available then. So is the board agreeable maybe to picking this up on the morning of Monday, March 23rd to finalize deliberations on HB 2561?
I'm okay with
That works for me.
Member Curry?
Yes, for me.
Okay. All right. I hate to cut into air fees because I think we might need 3 days for that, but I don't think this discussion will be very long. You know, so yeah. All right. And then at that time, we'll talk about, once we know what the rule is going to look like, then we can talk about the statement of reasons and how to move forward then. So I think we are ready to adjourn for the day. Are there any other matters we need to consider at this point? No? All right.
I'd move we adjourn.
Oh, I'll second that. All right. We're ready to adjourn. Thank you all very much.